What are we doing?
Thank you, Your Honor. At this time, my client is asking that a preliminary exam be set in this matter. Your Honor, we are asking for this to be set knowing that there is some outstanding evidence. My client has been in jail for 135 days, and we've asked for the DNA evidence multiple times. We just can't get the evidence. Your Honor, I'd also like to address bond when appropriate.
Okay. Well, I'll know because every time we come up to DNA, and I'm not going to ask when it's going to be here because who knows?
Which
that won't be the fact that if he wants an exam, he's going to have it. But the fact that they don't have DNA is not going to be the basis for an adjournment. You understand that, sir?
You understand that, yeah. Mr. Johnson? Thank you. Your Honor, when appropriate, I'd like to address bond.
Will the people have their witnesses available the 17th?
Do our best, Your Honor.
Preliminary examination, March 17th, 2026, 9 a.m. before Judge Moore. As to bond.
Your Honor, my client has currently been in for, I'm sorry, I misspoke, the line above. He's been in for 99 days. My client is very, very confident that the DNA on this particular item is not going to be his. He is asking if he could be tethered to his home. He's willing to do a GPS tether or even a home confinement tether. He does have medical needs that are not being addressed in the jail at this time. I have emailed about that, but there's, as the court is aware, there's things that they can do and cannot do. He has significant back pain and various other issues. Matter of fact, the day before this incident, he was at Trinity. Thank you, Your Honor. At Trinity before this. So we're just asking that he be released on tether, whichever type the court is inclined to allow. He still has his residency, and he's asking to be released.
Respond to the people.
Your Honor, it's my understanding the defendant was on parole at the time of this incident. I'm seeing an NDOC holder bond is denied as that bond continue.
Motion for bond reduction denied. Bond will continue. March 17th before Judge Moore.
Thank you so much, Your Honor.
Thank you.
They do. Since I told you you don't tell so maybe we
Court calls case People versus Jasmine Morris.
People.
And Assistant Public Defendant Nicholas Butkovich on behalf of Mr. Naparilla, who is now approaching. Please state your name for the record.
Michael Naparilla.
I have before me a plea form that indicates that he's going to be pleading guilty to a added count 2, I think, of use of fentanyl. The 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There's an agreement to no upfront jail.
That's correct, Your Honor.
All right. Let's have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you want to be the truth, the whole truth. Okay.
Sorry.
State your name, please.
Michael Naparilla.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Sir.
Understanding that you still wish to plead guilty?
Sir.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Or had one signed on your behalf?
Yes,
Is that correct? Any question regarding any of those rights?
Yes, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
I'm parole in Ohio.
Okay. At the time of this offense, were you on parole? Out of Ohio?
Yes, sir.
All right.
But they're aware of it.
Okay. I do have to advise you that this could be considered a violation of your parole.
Yeah.
If it is considered a violation, they could sentence you to the remaining portion of your term or send you back to do the remaining portion of your term or any other sanction in Ohio which would be available to them. You understand that, sir? All right. And understanding that you still wish to plead to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
And of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On May 25th, 2024, at the location of Gulfside Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have fentanyl in your possession? Did you use it? Did you know what you were using was fentanyl? All right. Sir, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
March 25th at 12 noon.
March 25th, 2026, noon, before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, at this time, I'll be requesting a personal reconnaissance bond. Mr. Naparua does have gainful employment. He does have a support system through his partner as well as his family. This case was just now reduced to a misdemeanor with an agreement for no upfront jail time. He will be willing to go and test and comply with any of the court's orders. He would test clean, obviously, as he has been in custody for a short amount, for this amount of time. He does have, again, gainful employment, a car, a support system. He'll be willing to
Aren't they gonna take him back to Ohio?
No. My wife had talked to my parole agent. They're not worried about it just because since I went to jail in parole, they knew about this charge when I was released. So they're not basically worried about it.
And he did, and XJO does show that the parole hold from Ohio was lifted. His parole agent did lift his hold, so he has no holds currently either.
I don't need a request from him. I'm gonna deny the request. I won't even consider release until such time as he's interviewed by my probation department.
Understood, Your Honor.
And that should happen relatively quick. Thank you. Bond will continue. Court calls case People versus Michael Roseberg.
Judge,
Alexander, on behalf of your people, Your Honor.
CourtTales Feaster, Assistant Public Defender, defend on behalf. Please state your name for the record, sir.
Michael Eugene Roseberg.
Thank you.
Yes, sir.
Thank you, Judge. I did speak to my client. I believe he is requesting this matter I believe we're requesting this matter be set for preliminary examination. To my knowledge, all discovery is complete. And I believe Mr. Roseberg would like me to address bond when you're done.
People, other witnesses available the 17th.
We'll try our best, Your Honor.
Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Moore. Pass the bond.
Thank you, Judge. He did meet with Mr. Niskar from our office this morning, and he did ask me to address his bond. He indicates that he is currently employed, fully employed as a night auditor / desk clerk for Quality Inn. He still has that job available to him right now. He'd like to make sure he keeps that job. He does have 4 children, 2 of which he supports via child support payments. He wants to make sure he doesn't get behind on those as well. Indicates he was last in trouble back in 2004 for a charge that has been resolved. He additionally indicates that he has his own place of residence right down the street here on Carpenter Road, and he would not have any contact with the alleged victim should the court release him. He would have no problem with a tethered home with work release, and he indicates he would appear for any and all court dates and follow any and all court orders. He'd expect either a PR bond or a $5,000 10% bond. He believes he can afford to post that if the court does grant a bond, Your Honor.
Your Honor, I'm going to object at this point. At the time of this offense, for the police report, Mr. Roseberg had a conditional bond out of favor of protecting the DP victims. There were 3 different victims. This occurred when they were out drinking with friends and while driving home. One person was driving and there were, I believe, 3 other women in this car. The defendant assaulted all of the people in the car by punching them. One of the victims had a buck on her forehead, a black eye, scratches to her arm and forehead. He also holds out of Adrian for disorderly for $100 and Van Buren for $500 for assault. He has previous convictions for breaking and entering, RNO, OWI, domestic violence, felonious assault, felony firearm, and larceny for courtesy, domestic violence, second. Those stemming back to 2011 and beyond. At this point, I'm going to object to the tax court.
I don't have anything further, Judge.
Motion for bond reduction is denied. Bond will continue.
Okay.
Thank you.
Thank you.
Thank you, Judge.
Thank you. Sharon?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Sharon. Would you say your name, please, sir?
Thomas Sharon.
Okay, I have before me a plea form that indicates that he's going to plead guilty to an added count 2 of entry without permission, a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct?
That is correct.
Yes, Your Honor.
They have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name, please. State your name.
Thomas Sharon.
All right, Mr. Sharon, it's this court's understanding you're going to plead guilty to the charge of entry without permission. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that, sir?
Yes, sir. Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed or had signed on your behalf an advice of rights form?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of February 18, 2024, Wise Hall at EMU in the city of Ypsilanti, Washtenaw County, state of Michigan, did you enter those premises?
Yes, sir.
Did you have permission to enter Wise Hall?
No, sir.
But it wasn't. Was it open to the public at the time?
Yes.
Or
I don't believe the hall is open to the public. It may not have been properly closed.
My understanding from watching the video, Judge, is that there's a security guard that you like get a badge in.
So
got it.
So I'm not sure.
So you did not have proper access, but entered the building anyway.
Yes.
And you knew you didn't have authority to enter the building.
Yes.
All right. Sir, if I accept your plea, if between the time that I accept your plea today and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would have to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
no, thank you, Your Honor.
No.
And have I complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
March 18th at 10 a.m.
March 18, 2026, 10 a.m. before Judge Barr. Bond continued.
Your Honor, may we address bond?
You may.
Your Honor, Mr. Sharon has indicated that, unlike at the time of the incident, which was, I believe, in 2024, he can stay with his sister who resides in Garden City. He says that he will return for all court dates. He will either be able to walk or take public transportation or have support from family. We are asking that the court consider a PR bond, especially given that the change in the charge.
Well, he didn't appear before, right?
Correct. That is correct.
Because he started out with a, so what you're saying, what changed from that?
He can reside with his sister, so he has a more stable situation now.
Well, I would have where's this, what city?
Garden City, correct? Garden City.
Well, I'm not going to change his bond. I will leave it at that. Certainly you can address that with Judge Barr as to that. But with his history before me at this point, I'm not going to change the bond. Thank you.
Thank you.